Everyone thought I was the fool, that I had missed my chance to sell, that I was too old and too stubborn to matter anymore. But they forgot I'm a land surveyor and a lawyer. Let me take you back 3 years. I'm Eli Mercer, 68, and I own a 40-acre plot just outside a rapidly growing suburb in Pine Valley. Developers had been circling like vultures, begging to buy my land. Every year, offers rolled in from companies wanting to build gated communities and golf courses. But I wasn't interested. That land had been in my family for generations. And even more importantly, it was tangled up with an ancient easement clause my grandfather had put in the deed. Most people had no idea what that meant. But I did. And I knew someone eventually would get greedy enough not to check the fine print. Enter the Crestwin HOA. About 2.5 years ago, I noticed construction equipment parked suspiciously close to my northern boundary. When I walked over, a supervisor casually informed me they were building phase 2 of their luxury development. 120 homes, a clubhouse, walking trails. I was stunned. On whose land? I asked. He laughed. Yours ended at the old creek line. We're building past it. No, you're not, I replied, dead serious. They waved me off like an angry old man. That's when I got to work. You see, the Crestwin developers had relied on a rushed county map overlay and a third-party firm that used outdated satellite imagery. The real, legally binding boundaries of my land were filed by my grandfather in 1963, with ironclad coordinates backed by surveyor stamps and notarized documents. Most people couldn't find those records, but I knew exactly where they were. What the developers thought was open city-owned expansion land was actually 16 acres of my private property, nestled on the far side of a dried creek bed that hadn't been visible in decades. So while they broke ground and built their model homes, I said nothing. I let them lay sidewalks, pave roads, install water lines, sell homes. They were so proud of their success, they even mailed me a brochure. That's when I struck. Once they reached the 100th home sold, I had my attorney file a quiet title lawsuit and submitted every original deed, coordinate survey, and easement agreement going back 60 years. The court was stunned. So was the HOA. Turns out not only had they built on land that wasn't theirs, but they had violated a family trust agreement that forbade any permanent structures without written consent. Every home built on my acreage was illegally placed, and every sale was based on fraudulent property claims. The judge issued an injunction. Sales were frozen. No more closings. Worse, the buyers of those 120 homes were technically trespassing. The HOA called me, panicked. We can pay you market value. I laughed. Oh, too late. They begged to negotiate, so I made them an offer. They could lease the land from me at a premium, or I could have the court order every home removed and sue them for damages, including lost timber rights, environmental disruption, and legal fees. Guess what they picked? Now every homeowner pays $875 a month in land lease fees to me. I even renamed the subdivision. It's no longer Crestwin Estates. It's Mercer Acres now. There's a big bronze sign at the entrance with my grandfather's name carved in, and I still live in my old ranch house at the edge of the property. Every morning I sip coffee on my porch and wave to all 120 neighbors living on my land. Funny how the man they thought was the fool turned out to own the whole board.